Good morning, everyone, and thank you for attending today's webinar, New Call-in Pay and Worker Scheduling Requirements Proposed in New York. Before we begin, we wanted to cover a few housekeeping items. At the bottom of your screen are multiple application widgets. A copy of today's slide deck is available in the resource list. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. If you have any questions during the webcast, you can submit them through the Q&A widget, and we will try to answer these at the conclusion of the webinar. Finally, please take a moment to complete the brief survey at the conclusion of today's presentation. I would now like to introduce today's presenter, Andy Bobrecht, a member of the firm's Labor and Employment Law Department. Andy focuses his practice on assisting employers with minimum wage, overtime, and other compensation issues arising under the Fair Labor Standards Act and New York labor law. He regularly represents and counsels owners, contractors, and subcontractors to ensure compliance on prevailing wage projects under the New York labor law and under federal law. Andy has defended employers facing wage and hour claims in both administrative proceedings and court actions, and has represented clients facing governmental audits of their wage and hour practices. And without further ado, I will now turn the webinar over to Andy. Good morning, Andy.
Hey, good morning, Kathy. Thank you very much. Good morning, everyone. It is a beautiful sunny day here in Syracuse, like always this time of year. We appreciate having you with us. I know we have many clients who have joined the webinar today. We have the best clients in the world. We appreciate you. We appreciate you joining us. I know we have many friends here on the webinar too. So thank you too for attending this presentation. So I know that if you're attending this webinar, you are in some way involved with HR in some manner at your institution. I also know that you are having to deal with many significant legal developments here in New York of late. And here we have yet another major and potentially very challenging and costly change being proposed in New York. We've entitled the presentation as dealing with call-in pay regulations just for the sake of simplicity, but it actually goes a lot farther than that, as you'll see. We've also just scheduled this presentation for 30 minutes. We want to cover the basics today. We know your time is valuable. We know you only have so much time to dedicate to these types of developments. But we really just want to give you the basics so that you can become conversant in what is being proposed, start explaining it and planning with your operational and scheduling staff. I realize that might be you too, but so that you can start thinking about this and planning accordingly. I do hope that we have some time at the end for some questions and answers. Please feel free to use that feature. This is a very widely attended event, so I do not think we will be able to answer all questions, but I encourage you to submit them. My thought is that we may do a blog post on our blog, the New York Labor and Employment Law Report, after the webinar to try to answer these common questions that we see come up in the course of this presentation. So again, fire those questions away, and if we can't get to them today, we'll try to get to them through some other means. So we're here to discuss call-in pay regulations. These regulations were just recently proposed before the holiday on the 22nd. They were formally published in the State Register. They are currently open for a comment period. And again, I just want to emphasize that they've just been proposed at this point. They're not final, and they are subject to change. As to when they may become effective, that's really an open question. For those of you who have attended some of our webinars in the past who are keen to these issues in New York, the New York State Department of Labor has done a considerable amount of rulemaking over recent years. And frankly, they've taken several different approaches as to how to implement the regulations that have been initially proposed. So the way I see it, I don't have a crystal ball, and we're not peeking behind the curtain in Albany, but I think it could take several different forms. One, the regulations could become effective immediately once published after the 45-day period. There could be no changes to the regulations as they stand now, or they could be published in final form with some changes. This could also be the case, either published as they are now in final form or with some changes, but with a delayed implementation date. Right now, the regulations do not contemplate any delay in the implementation date, but that's something we've seen in other rulemaking efforts from the Department of Labor. These regulations could be revised and opened up for another comment period, or they could just sit for a significant period of time after the comment period closes. We've seen that happen too. Again, I don't have a crystal ball, but my sense is that there is a desire on the part of state regulators to push these regulations, and that it is likely they are going to push to move forward with these as soon as possible. And so we could see some kind of final action in the first part of next year. And of course, that makes it all the more important that you start preparing now to the extent we can. Well, so where did this all come from? This has actually been an issue we've been keeping our eye on for some time. The issue of on-call scheduling or on-demand scheduling of workers is something that we've seen raised by various pro-labor groups and the labor movement across the country and here in New York too. Here in New York, it really began a few years back with a letter that the Attorney General sent to 13 major retailers in the state, questioning them about their practices of on-call scheduling. They asked for any call-in policies that these large employers had. They asked for payroll records and other sample schedules to assess this, and when they made that communication, raised that there were potential compliance issues that could arise. That then was followed by a multi-state AG inquiry where AGs from 9 different jurisdictions, including New York, wrote to 15 large national companies and again raised the issue and questioned their practice of on-demand or on-call scheduling of workers. As a result of those inquiries, there were 9 retailers who said that they didn't engage in this practice or had recently ended it, and there were 6 companies who, as a result of the AG's inquiry, expressly acknowledged that they would no longer engage in the on-call or on-demand scheduling of workers. Hearings were then held here in New York just recently in the fall, and of course, as mentioned, the regulations were published in draft form just a matter of days ago. I was a bit surprised, frankly, at the speed with which the regulations were published following the hearings. But I will tell you, this issue, the on-call or on-demand scheduling of workers and the enforcement efforts on the part of attorney generals across the country has been picked up by the national media. They have received some traction there. And I think through that process likely realized that there wasn't enough law on the books, so to speak, to be able to really take the firm enforcement issue they wanted to on this so-called on-demand or on-call scheduling of workers. Now, I'll share with you the reported rationale for why regulators are focusing on this issue, and it's that, according to studies and hearing testimony that was offered, it has an adverse impact of workers who are typically low-wage workers who are harmed when they are provided an opportunity to work with little or no notice, or their shifts are canceled in advance with little or no notice. It puts them in a difficult position to arrange for child care or perhaps even having to pay it just on the chance that someone may call them to work. It adds stress to their lives. They're unable to work a second job because of having to be available for the first job and the uncertainty associated with that. And there were other rationale too, but that was the, if you will, public policy that was pushing the regulators to propose these regulations, hold the hearings, and for the original inquiries from the attorneys general. I'm not here to dispute those notions today, but do question the prevalence of these on-demand, on-call scheduling practices, and I'm comfortable sharing my view that they go quite far in limiting the scheduling flexibility that employers would have if these regulations are enacted. So first, who's going to be impacted by this? Well, the regulations amend the miscellaneous industries minimum wage order here in New York. I commonly refer that as the catch-all minimum wage order in New York. There are provisions in that minimum wage order that also provide coverage to certain nonprofit entities. So if you're a nonprofit entity, you could be covered as well by these changes. This particular minimum wage order does not cover New York State, does not cover municipal governments, and it does not cover political subdivisions generally. Those are generally excluded from coverage under the minimum wage law here in New York. So I think that's an important point. And also, these particular changes are not being applied to other minimum wage orders in New York, such as the building services industry minimum wage order or the hospitality industry minimum wage order. And according to the State Department of Labor, when they publish these regulations, they're looking with an estimate of 1 million or so workers who would be impacted by this. Frankly, that number seems a little low to me. I feel as though this will have a much broader impact than that, but time will tell, I suppose. And I guess for those of you out there who do engage in on-call practices, have frequent call-outs from work, or who work irregular work schedules, it's particular to note these regulations. They could have a dramatic impact on your operations. Sorry about that. We're just having a lag here in the slides coming up. Give us just 10 seconds. Thank you. All right, thank you. So what's currently required under the law? And again, when I say law, I mean the miscellaneous industries minimum wage order. So for non-exempt employees who report to work on any day, they get call-in pay equal to the lesser of either 4 hours of pay or pay for the number of hours in the regularly scheduled shift at the state minimum wage. This law has actually been on the books for many years, but frankly has had a fairly minimal impact for employers insofar as under case law and under the New York State Department of Labor's interpretation, it really only affects employees who, non-exempt employees whose earnings are at or near the state minimum wage. And I can explain how that works just briefly for you. But essentially, to the extent that you pay an employee, a non-exempt employee, above the minimum wage, you get to total up how much more you pay them above the minimum wage during the work week, and then use that amount to offset any call-in pay that may otherwise be due to the worker. So for example, let's say a part-time employee works Monday through Thursday, works a regular 8-hour shift, and earns $11 an hour. So you have 4 days that week, Monday through Thursday, at 8 hours a day times 11 hours, $11 an hour, that's $352. On Friday, they come in to work their usual shift, but they only work 2 hours of that shift, of that 8-hour shift, and they're sent home, and they would otherwise get paid $22. So the total that they're paid is $374. Now, the way to figure out whether or not under the current law you need to pay them any additional for the call-in pay, since they were sent home before 4 hours in that case on the Friday, you take a look at how much they worked that week, so a total of 34 hours, multiply that by the state minimum wage. Here in upstate New York, it's $9.70 an hour. That gets you to $329.80. Then you take the 4 hours of call-in pay at the state minimum wage, which is $9.70, so that totals $38.80, which is a total of $368.60. Now, because you paid, the worker would be paid $374 because they earned that $11 an hour for all hours worked, there would be no additional call-in pay obligation in that situation. And again, I wanted to walk you through that because that offset's important. It's important because it again, has the practical effect of really minimizing the impact of this call-in pay requirement as it exists under current law. And again, most importantly, too, employers are generally free to schedule and, if necessary, cancel shifts before a worker comes in without incurring any additional pay obligation. So let's get into the nitty-gritty of what's being proposed here. And I think it's important to note that in situations, not only when employees actually come into work, but also they will receive pay for situations when they're not coming into work and they're not performing any actual work. So I think these next two slides really are the most important ones for you to focus on and to consider moving forward. The first one would be a situation where there's an unscheduled shift. Again, this is a new requirement. If an employee is asked or permitted to report to work for a shift that's not scheduled 14 days in advance, then they must receive 2 additional hours of call-in pay. And for all these new requirements, the call-in pay that they have to receive, and I'll mention this again later, is at the state minimum wage. And again, here in upstate New York, that's $9.70 an hour, but it will change at the end of the year, and it does vary by jurisdiction, where the business employees are located, and also by the size of your particular business. Second, if a shift is canceled within 72 hours of the start of that shift, then an employee must receive at least 4 hours of call-in pay. The third new requirement is that if an employee is required to be available to report to work for any shift, essentially on call, then that employee must receive at least 4 hours of call-in pay. This one is especially notable to me for a number of reasons, but most especially it appears, although it's not entirely clear, it appears on its face to indicate that if you're simply asking an employee to be on call and otherwise free to engage in any personal pursuits, situations that may not otherwise be compensable hours worked under state or federal law, you may nevertheless be obligated to pay them for 4 hours of call-in pay. Again, this provision is not entirely clear based on the drafting nor the intent. It's one where we hope there will be clarification, but certainly is notable for its reach. And finally, the fourth new requirement being proposed is that if an employee is required to be in contact with the employer within 72 hours of the start of the shift to determine whether or not to report, then they get an additional or at least 4 hours of call-in pay. So there's a lot there. I know these requirements are somewhat straightforward on their face, but when you dive into them and start thinking about the different situations that may apply, it can quickly get complicated. And all I can tell you on that front is we are reviewing them in detail. We're trying to give thought to those various circumstances that may impact your business, and we're going to do our best to get as much general guidance as we can out there for you. Additionally, the proposed regulations will also amend the old reporting to work requirement. So that's still going to remain on the books too. And what you see here, the red text will be the new text. The black text is the existing text. And the strike through is what they're eliminating as part of the proposed regulations. So in short, if an employee reports for work on any day, now they changed that to shift. On any shift, they shall be paid for at least 4 hours of call-in pay. So those are the circumstances when the call-in pay could be triggered. The next question is, all right, well, how do we calculate that? And the regulations do provide guidance on this. So one thing that the regulations make clear is you have to pay employees for time they actually attend at work. You have to pay them the regular rate or their applicable overtime rate, less any allowances that may apply. So, for example, if they are provided with meals or housing and you can take an allowance under the law for those, you can consider that when you're paying them for their actual time of attendance. However, you cannot apply any of those allowances to the call-in pay you may otherwise be obligated to provide to the workers. Now, in certain circumstances, if you have an employee who normally works a shift of less than 4 hours, you may be required to only pay them for the time of that lesser shift at the state minimum wage rate. Notably, this only applies to the reporting to work situation or the canceled shift situation. And they've added a number of additional requirements here, that additional hoops that you'll have to jump through if you're going to try to rely on the fact that, well, we don't have to pay this employee 4 hours of call and pay because they're regularly scheduled to work 2 hours. One of those requirements is that the employee's total hours worked or their schedule to work for that particular shift doesn't change from week to week. So if there's any variability, as you see it here, as is the case in many jobs, it's going to be that 4 hours that applies, and you're not going to be able to take advantage of the fact that the employee may even frequently work a shift of less than 4 hours. Regarding the calculation of call-in pay, according to the regulations, it doesn't count as hours worked. It does not need to be included when calculating an employee's regular rate. And this is, I think, perhaps the most important thing here. It shall not be offset by the required use of leave time or by payments in excess of those required under the wage order. And so, again, this language is not entirely clear, but I think it's possible that what they were doing with this language is to try and close the offset interpretation that was previously provided under the minimum wage order. In other words, you're not going to receive any credit for amounts that you pay an employee above the minimum wage when figuring out whether you have to pay them any call-in pay under these new requirements. So let me give you a quick example of how I think this could work. Again, it's not entirely clear, but let me give you an example of how the reporting to work pay could work, I think, in the calculation. So let's say you have a part-time employee who works Mondays and Tuesdays and works 2 10s, all right? So works 20 hours over those 2 days at $12 an hour, so they make $240. They're called in on Wednesday unexpectedly. There's no other exceptions that we'll talk about in a minute that might apply. The shift that they're coming in to cover is normally a 10-hour shift, and there's a large shipment coming in that they need to help with. So the employee comes in that Wednesday and works 1 hour, but is sent home because the shipment doesn't come in as expected. Normally the employee would be paid 1 hour at $12 an hour. So let's figure out what we may owe under the proposed regulations here. The employee was called in to report on that Wednesday, and so under the proposed regulations, it looks like that employee would be due 3 additional hours at $9.70 an hour if it was upstate New York. That's the minimum wage, for a total of $29.10. The employee had already received at least 1 hour of minimum wage for that hour that he came in on the Wednesday, so you get a credit for at least that, but you don't get a credit for the additional amount you paid above the minimum wage for that hour. So as I referenced just a second ago, there are several exemptions that have been proposed. First and foremost, not all employees are covered under these minimum wage orders, right? Bona fide professional, executive, administrative employees, and for executive and administrative employees who earn a salary above the minimum threshold, they're exempt from the minimum wage order as well as other classifications of workers. Employees who are covered by a labor contract that provides for call-in pay, they're exempt under the regulations. And this is, I think, a big one, and one you'll have to take note of, that employees during any work weeks when their weekly wages exceed 40 times the state minimum would not be covered on these call-in pay requirements. That's just, though, the 4 new scenarios that we're talking about with this exemption. So again, I think just on that particular one, the focus is on part-time employees, or you have a part-time employee who earns a very high wage such that they earn more than 40 times the minimum wage for that period. They would not be covered for the 4 new call-in pay scenarios. Additionally, in the unscheduled shift scenario, the call-in pay requirement would not apply to new employees during their first 2 weeks of employment. Also, it would not apply for the unscheduled shift scenario to anyone who's regularly scheduled and who volunteers to cover another shift. And it's particular shifts that they can volunteer for without incurring any call-in pay obligation. It's either a new or additional shift or a shift scheduled for another worker 14 days in advance. Commonly, employers who have an abundance of part-time staff or whose operations are sensitive to seasonal elements or weather will have pools or voluntary arrangements where employees can exchange voluntarily to cover one another's shift. This will impact that. It'll impact it in a number of ways, and I think it'll make it much more complicated because, A, the person whose shift's being covered will have to have been scheduled 14 days in advance, and additionally to be a regularly scheduled employee who can volunteer to cover the shift for the other worker has to meet a number of requirements, including that they're regularly scheduled. That has a particular meaning. They have to be scheduled 14 days in advance for their own shifts, consistent with a good faith estimate of the hours provided at the time of their hiring or when the regulations go into effect, whichever later. And I think there's a number of open and unanswered questions at the current time. Obviously, there's a lot of complexity, and I feel for you now, having gone through that, I'm sure you're thinking, goodness, how is this going to impact our operations? How can we structure things properly? Those questions are certainly first and foremost, but there's others too that we're considering. The labor contract exception. All it says is a labor contract that expressly provides for call-in pay. Employees who are covered under that contract are exempt. It doesn't explain what kind of call-in pay needs to be, if any, required under the labor contract, and so there's a question as to the coverage of that and how far does that exemption apply. I mentioned to you the offsets and the offsets that you could apply previously under current law for amounts that you pay workers above the minimum wage. Again, it looks like, it's not entirely clear, but it looks like they're trying to curtail and end that practice. And then as the regs stand now, it appears that if you had a worker who was on call and was required to be available to come into work, they earn at least 4 hours of call-in pay. And additionally, if you then call them into work, and they could be due an additional 4 hours of call-in pay. So there could be a total of 8 hours there of just call-in pay that you'd have to factor in. What's a shift? The term shift is used predominantly throughout this. And again, I think on the call-in pay provision, this is especially relevant. So let's say you have an employee who's on call over the weekend. Well, there's, in theory, on Saturday and Sunday, let's say it's 8-hour shifts. There's 6 8-hour shifts total that would encompass the weekend. And so you think about that, it's 6 shifts and 4 hours of pay times each shift at $9.70 an hour. Here in upstate, it's $232.80 call-in pay, potentially. Again, I mentioned the impact on voluntary employee exchanges. I talked a little bit about the notice provision. If you want someone who can volunteer for another shift, they're going to need to have their hours regularly scheduled, consistent with a good faith written estimate that you've provided to them already. And I know you've heard a lot of PFL here in New York, but to me, that's a major consideration too. We're going to be rolling out this significant new benefit in New York that's going to allow employees to take small increments of leave here and there, and so you could see more call-outs in the future that will raise these scheduling issues where perhaps they didn't exist before. So, and I know we're running over. We do have a few minutes of extra time here, and want to just cover these, and I'll try to answer a few questions for you as quickly as possible. I think the most important thing to do is to review the requirements and become familiar with them. To really give some thought to how they can impact your operations and scheduling. I think one of the most important takeaways is to remember that an employee gets 2 additional hours of call-in pay if their shift is not scheduled 14 days in advance. I don't know, I've worked with some, but the vast majority of employers who I've worked with over my career don't schedule their workers 14 days out in advance, and many times they need and have to use a flexible model that responds to ebbs and flows of business and customer demands. But that 14 days is what they're proposing. And of course, I would encourage you to monitor this issue for any further developments. We will post updates and any other significant information on our blog, the New York Labor and Employment Law Report. You can access that blog through our website, bsk.com. And finally, I would encourage you to submit a public comment. It's open 45 days. It actually runs till Saturday, I think the 6th of January, which should then push that back to the following Monday. But just to be safe, I would encourage you to get your comments in by the 5th of January. And one thing I noted in this is there was repeated mention that these regulations are not going to impose any mandatory costs on the regulated community. That's you. And employers can simply avoid the call-in pay by implementing proper scheduling practices. But for those who have seasonal elements to their business, who need to be nimble and flexible in response to customer demands, you can't always avoid those issues and plan for these types of scheduling issues 14 days in advance. Now there are some exemptions, as we mentioned before, and those are important to keep mind of, and they include acts of God and other weather-related situations that are outside, or other situations that are outside the control of the employer. So those situations could help. But again, they don't apply to all situations either. All right, so why don't we have a couple extra minutes here, I think, and why don't we try to take a few questions. So the slides, we have some questions about the slides being available. As Kathy mentioned, you can access the slides through the system right now. If you need them afterwards, just send us an email. We can send you a copy. We're happy to do that. I had a question about the weather. So my business is highly weather dependent. Is weather an act of God or other cause not within the employer's control? As I mentioned, there's an exemption for the canceled shift situation where there is an unforeseen act of God or weather event. I would hope they would interpret this exemption to apply to weather-related issues. I think they should. The text of the regulation talks about states of emergency, though, and it could be read to imply a higher type of event than just your typical weather. But to me, weather is a situation that's certainly outside an employer's control. But remember, again, it only applies to the canceled shift situation. And if operations continue and it's just a lower staffing need that you have, what the regulations say in that situation is, well, all we're going to do is reduce the 72-hour notice obligation and reduce it to a 24-hour notice obligation. So if you give somebody less than 24 hours notice that their shift is being canceled because of lower staffing needs, you will still have a call and pay obligation for them. I think we could do one more here. So I don't have to worry about employees who make more than minimum wage. Well, that's a good question, and I think we want to make sure we understand what is actually in the regs and what's being proposed here. So the new provisions, that's the new 4 provisions, not the reporting pay provision, but the new provisions don't cover employees whose weekly earnings exceed 40 times the minimum wage. So you're going to have to look at where are they working and what's the applicable minimum wage in that area. So an employee who works, let's say, who earns $30 an hour but only works 20 hours a week, well, they would be exempt even though they only work 20 hours a week. It's not just full-time working 40 hours. You have to say, look at how much do they actually earn during that week. They would be exempt because here in upstate at least, they make $600, and 40 times $970 an hour is $388. The implicit point there is that you have to keep doing this week-by-week analysis. It's not a perpetual exemption. It's if they make more than 40 times the minimum wage that week, then those new 4 requirements don't apply. And again, the report pay obligation still does apply, even if they make more than 40 times the minimum wage. And finally, just to reiterate, I would mention that if the employee is not a covered employee in the first place under the applicable wage order, then they are exempt. So I'm sorry we ran over there just a minute. We do need to bring this to a conclusion. I thank you for your attendance. I thank you for joining us. Again, we'll be in touch further regarding this issue. I expect that we'll do another webinar once any further regulations are proposed, whether in further draft or final form. We're going to take your questions, and we will look at those. We'll try to get some guidance out in response to those questions. I know you'll have a lot of them. And stay tuned to our blog, stay tuned to our Twitter account. We'll get the information out that way. Finally, you'll get a survey at the end of this presentation. I would ask you to please consider completing it. I look at those. The firm looks at those. We take them very seriously. We want this presentation and these types of presentations to be a good use of your time. We strive for that. We give a lot of thought to it. So your feedback is very much appreciated and very much welcome. So with that, we'll bring the webinar to an end. Thank you again for your attendance and hope to talk to you soon. Thank you.